all over the world, people are adjusting to the new normal brought on by the coronavirus pandemic. The pandemic has disrupted people's way of life, with technology now playing a more visible role. Now, Nigeria's judiciary is also having to adapt to this new reality with the introduction of virtual court proceedings. But the fact that these new procedures were introduced due to a prevailing situation, some key players in the sector are kicking against it. Now, other issues on the top burner in judicial circles is the federal government's plan to set up special courts for speedy trial of rape and gender-based offenses and issues that will help decongest correctional centers around and across the country, among other issues that need the call for special courts to be set up. Now, joining us in the studio is a lawyer, Dr. Babatunde Ajibade, SAN, Senior Advocate of Nigeria. It's nice to have you join me this morning.
Thank you very much.
Great. Now, when you sit down and look at the judiciary from a holistic point of view, and you see the ratings when it comes to corruption and how things are not okay, and one of the institutions is the judiciary. In the past few years, the NBS has come up with ratings which said that the judiciary is among some of the, I think about the top 3 institutions that are most corrupt, and things are not going on well in the country. What do you make of that? How does that trouble you?
It troubles me significantly. I think it should trouble anybody, because there's no civilized society that's going to survive for long if it doesn't have a judiciary that commands respect. So it troubles me. I think the perception may be worse than the reality, but whether it's perception or reality, the fact that it exists at all is a challenge, because once society doesn't have confidence in the judiciary, you know, you have the kind of problems we're seeing now. You have people resorting to self-help, and you have generally, you know, breakdown of the structures of civil society. So it is a significant problem, and we have to fix it.
Okay. Now, when the president came in, President Muhammadu Buhari, in 2015, one of the issues he talked about, in fact, one of his core cardinal points was the issue of fighting corruption. And he expressed some level of reservation as to the judiciary not being a committed partner in the fight against corruption. And he talked about the issue of setting up special courts for that. And right now, on the front burner in the recent weeks has been the issue of special courts for rape, you know, and violence and all of that. But this generates a lot of divergent views amongst people. What is your opinion? What do you think is the best way to handle them?
I'm not a fan of special courts. I think it's a form of evasion when we talk about special courts, because the courts are important. The courts are important at all times, not just for rape, not just for gender-based violence. They're important for fundamental rights enforcement. They're important for commercial transactions. They're important for constitutional issues. So I think our court system is not working properly. And I think it is avoiding that problem to now start talking about creating special courts for special matters. We should fix that court system and look for a holistic solution.
But when the courts are overwhelmed with a lot of pile-up of cases, and special courts are set up to expedite some of these cases, wouldn't that be a welcome development?
No, my view is that you should fix the court system.
How do we fix the court system?
Because they're under-resourced. Okay. We don't have enough judges. We don't have enough courts. So we need to put the resources into that sector, because if you're going to create special courts, you're going to take some out of that existing system to go and man these special courts. I'll give you an example. One of the greatest challenges we have in the system today is the fact that because of our the way we're running our democracy, and when we have election season, you have judges being seconded to go and sit on election petition tribunals. Now, the election petition tribunals are a type of special court which are created just for the election period. When the judges go and perform that role, they're abandoning their role in the regular court system, and that backlog you were speaking about just continues to pile up. Now, if you want to create a special court for rape, you're going to take some more judges out of that same system to go and sit in that special court. then the other cases are going to pile up. So I think we're avoiding the problem. We should deal with the problem rather than avoid it.
All right.
We should put more resources into the sector.
Right. When you say we don't have enough judges, what is responsible for that? Because we don't have records that judges, the brain drain is affecting, lawyers, where a lot of them are leaving the country, just like we have in the medical profession. We don't have that record, they say. So is it, why do we not have enough when the law schools are churning out lawyers on a yearly basis?
I think that is the big elephant in the room, and that's what that's the point I'm making. That is what we really need to confront. And okay. I'll tell you what I know. I don't have all the answers, but I'm going to find out. I know that as a percentage of the national budget of this country, the budget of the judiciary has consistently reduced. Not in absolute terms, but as a percentage. Okay. So the population is growing, the number of disputes are growing, but the judiciary is not growing to keep pace with the size of the problem that it has to deal with. So we have a challenge. And this is one of the things that I said our profession must confront and deal with holistically. The other day, Mr. President came up with Executive Order number 10. Some people have different views about it as to whether it's constitutional or not. The intent is good. So that is one thing. But there's a more significant problem. Giving financial autonomy to the judiciary, as far as I'm concerned, it's a secondary issue to financial autonomy over what? Because you can only have financial autonomy over what has been budgeted for you. The fact is the budget, the amount of resources that are allocated to the judicial sector. And then secondly, I made this point recently, and a very distinguished Nigerian pointed out to me that, well, even what has been budgeted, whether you say it's adequate or inadequate, is it properly managed? And I said, of course.
That's another aspect of it.
That's another problem entirely. So we've got two sides to the coin.
Right.
First, inadequacy of the budget. Second, proper management of what is indeed budgeted. And these are issues that I think we just need to tackle head on if we're going to solve this problem.
All right. A lot of Nigerians, when we sit down and we listen and we watch some of the proceedings in the South African court or in the Kenyan court or in the British court, we hail them. But when it comes back to Nigeria, there's this skepticism or this cynicism about, in fact, before a case is even decided, some Nigerians have a perception of how it is going to go and all of that. If we have to reform that system, if we have to change that perception, what drastic thing do you think has to be done for reforming the judiciary?
I think reforming the judiciary requires total reformation of the profession that gives rise to the judiciary. Okay. Because one of the things that I consistently stress is that the legal profession needs to be united. Okay. Judges are not called to the bench. They're called to the bar. They were lawyers. And for a justice sector to work, the bar and the bench need to be working together. The bar and the bench need to realize that jointly they're service providers to society, to disputants, to government sometimes on one side against the citizen, to citizen versus citizen. Now, right now, that synergy is not there. I think that we need to retrace our steps. First, legal professionals need to realize that they have a significant role to play in holding society together. When you spoke about corruption in the judiciary, and I said, the perception and the reality, there's no doubt that there's corruption in our judicial system. But then I personally think that the perception is worse than the reality. So
you don't think it's as bad as it is?
No, I don't think it's as bad, but that is not to because what you have, if you let me explain, yes. It's sometimes difficult. It's practically impossible to prove corruption. It's very rare that you'll be able to prove corruption in a judicial process, because a judge who has been corrupted and a litigant or a lawyer who has corrupted the judge are very unlikely to own up to the fact of corruption. So it's an illicit thing. It's very difficult to prove. So the way in which you would typically try to prove it is when you see judgments that you think, this is not quite right. But then in an adversarial system of dispute resolution, there will always be a winner and there will always be a loser. Now, if you allow that perception or that belief that there's corruption in the system to become so ingrained that every time a litigant loses a case, or every time a lawyer loses a case, he accuses the arbiter of corruption, then you have a significant problem. And that is where we are now almost. And sometimes the results you get is not corruption, it could be incompetence, because judges can be right, they can be wrong.
Okay. Now, recently, one other issue that was in the mind of Nigerians, or on the lips of Nigerians, and especially even lawyers, was the issue of virtual proceedings, where the realities of COVID-19 brought that up, and there was the controversy as to whether it was valid, it was supposed to be valid or not valid. What do you make of that?
Again, with the greatest respect to all of us in the justice sector, as I like to call it, I think we're focusing on the less important issues. Virtual court hearings have been going on in other parts of the world even before COVID-19. We're trying to play catch up. But unfortunately, here we go again, focusing on technicalities. Oh, it's not constitutional.
Rather than the substance.
Rather than the substance, because the substance goes back to what I said. Right now, we should be tackling what is it going to take to make these virtual hearings work. There's significant resources that are going to be required in terms of infrastructure, in terms of know-how. The judges would need to be retrained and retooled. Even the lawyers would need to be retrained and retooled as to how to use this system properly to improve the efficiency of our justice sector. Recently, the Supreme Court was given the opportunity to resolve the issue when Lagos and Ekiti State Attorneys General took cases to the court precisely to try to get a pronouncement that would lay this issue to rest. Unfortunately, the Supreme Court declined to give us the certainty that we're seeking. So virtual court hearings definitely are here to stay, but we need to cross that hurdle of their constitutionality and then focus on getting the resources that would make them viable.
Okay. All right. Dr. Babajide Akinbade, thank you so Ajibade, rather, Senior Advocate of Nigeria. Thank you very much for talking to us.
My pleasure. Thank you very much. Thanks for having me.